Welcome. Today is Wednesday, February 22nd, 2023, and we are going to talk about damages. Specifically, we're going to talk about several liability. We started out this morning in class room 227. It was a sauna, way too hot to have class. So here is the lecture that I said that I would post along with the PowerPoint so that you would have the information that we would have covered today. And then this way, we don't lose a lesson. Here we go. PowerPoints were posted this weekend to all of the classes that we've had so far this semester. Video links for all of the classes that have been recorded were also posted this weekend. Friday, February 24, we're going to review the Trehan LaRoche case. Friday, February 24, we're going to turn in the Levitt v. Peluso case. Monday, February the 27th, we're going to review the Levitt versus Peluso case. And Monday, 27, we're going to have a general review of damages as they are apportioned. The burden of apportionment. We are going from joint and several liability to several liability. What do we mean by the apportionment of damages? How do we determine how much each tortfeasor, that is the person who's deemed to have been negligent, how do we determine how much each tortfeasor is going to be responsible for compensating the plaintiff who has been injured by the conduct of that tortfeasor? As we planned class today, I plan to have Ms. Kilgore and Ms. Everett give us a working definition of joint and several liability. But since we're doing it via remote posting, here's your working definition. Two or more tortfeasors, defendants, negligent parties are independently liable for the full extent of the injuries stemming from concurrent tortious acts. That's joint and several liability. If you need a case to think about as you're thinking about joint and several liability, that is going to be the Carolina v. Hill case. The Carolina v. Hill case is the perfect case that explains joint and several liability. Carolina v. Hill was the one with the railroad, the lumber company, blasting, taking down timber, excavating, doing lots of things that are destroying this family farm for all intents and purposes. The farmer decided to sue two of the defendants. One of the defendant is named as the one who's going to be responsible for paying the damage for all of the guilty tortfeasors. That one defendant who's paying said, "That's not cool." The response was, "Yeah, but that's the law." Okay. Joint and several liability is one method of apportioning damages. Second method of apportioning damages is several liability. If we were in class, that would be Kimball and Fairley, who would give us a working definition of several liability. But since we're not in class, here we are. Pure several liability holds defendants liable only for the damages to the plaintiff they are actually responsible for, right? The damages are going to be related to the percentage of fault that that particular defendant holds. Got it? Joint and several, one for all for one. One guilty defendant can pay the total damages for multiple negligent defendants. Several liability, Each defendant will pay only their respective damage as it is determined by their percentage of fault. Take a break. Make sure we're understanding the difference between the two, because as you prepare for tests, as you prepare for the bar, what you're going to need to know is the difference between the two doctrines, okay? Let's take the Piner v. Superior Court case, for example, because this is a really good example of not only several liability, but we're going to have a new doctrine of law introduced here. And that new doctrine of law is the indivisible injury doctrine. Indivisible injury doctrine. I would have asked Barbie, Bellato, Morgan, and Moore to give us a procedural history of Piner, but here's the procedural history. Piner sued Jones and Richardson. Piner is the plaintiff. Jones is defendant 1. Richardson is defendant 2. All parties agreed that the injuries suffered by Piner, that's the plaintiff, were caused by Jones and Richardson. What the parties couldn't agree on is whose responsibility it was to determine how much damage, whose responsibility was it to apportion the damage between the two guilty defendants. Piner moved for a motion for summary judgment based upon the issue of joint and several liability. Richardson, which is defendant 2, responded and said, no. Arizona law has abolished joint and several liability. The responsibility of determining the apportionment is on the plaintiff, not on the defendant. Oral argument was heard before the judge could leave, not for the day, but leave their position as that presiding judge. No decision was made. A new judge came in and said, based upon the notes, the oral argument, and the direction of the previous judge, the new judge felt that they were bound to deny the motion for summary judgment in favor of defendant 1 and defendant 2, and find, F-I-N-D, that plaintiff, that is Piner, has the burden of establishing the apportionment of the damages between the two guilty defendants. And if the plaintiff was unable to divide the indivisible, then the result for the plaintiff would be, sure, you're innocent, sure, you've been injured, sure, that sucks. But since you can't tell us what defendant did what damage, you go home empty-handed. Feeling, understanding, realizing that that was short of justice, the new judge granted a continuance for the plaintiff, Piner, to file a mandamus motion before the appellate court for emergency relief. The appeals court declined jurisdiction for the mandamus. They chose not to hear it. The Supreme Court of Arizona granted certiorari. Here we are. Piner v. Superior Court. What's the issue? Jimenez, Marshall, McClary, Bass. What's the issue? If you identified both issues, bravo to you. I say that Piner is probably the hardest case that we've briefed this semester. I thought maybe it was a tie between Piner and the World Trade Center, but the World Trade Center was difficult because it was cumbersome, right? There was a lot going on. There was a lot involved. It was just big, not only in page numbers, but in all facets. It was just a lot, right? Pioneer is difficult because of the nuances, Let's look at the issue. Better yet, let's look at the issues. 2 issues. Number 1, you can guess, you've read it, you've seen it, most of you identified it. Who has the duty to apportion damages? Is it the plaintiff or is it the defendant? Here you heard plaintiff say that's the responsibility of the defendant. And if the defendant can't do it, then let them suffer joint and several liability. You heard the defendant say, don't think so. Joint and several liability has been abolished. So it is now the plaintiff's responsibility to apportion the damage. And if the plaintiff can't do it, then the plaintiff goes home empty-handed. What do you think? Do you think it should be the plaintiff who has to divide the indivisible? Or do you think it should be the defendants who should have to divide the indivisible? Who gets to make the decision? Who tosses the coin? Who gets to choose first? That's the first issue. Where does this burden lie? We have to establish where the burden lies as far as it relates to how are the damages going to be apportioned. But that is only the first question that has to be answered. The second question that must be answered is, once we decide the apportionment of damages, are those damages going to be subject to liability rules of joint and several liability? Or are those apportions going to be subject to the liability rules of several liability? Edwards, Hill, Horton, Kimball, Lane, C. Lewis, I would ask you for the facts, the key facts, the dispositive facts, the facts that turn this case. But for these facts, we wouldn't have a case. So I'll go through them briefly. Plaintiff is driving. Plaintiff yields to a pedestrian in the crosswalk. Nice plaintiff. Lets the plaintiff clear the crosswalk. Defendant 1, Jones, isn't paying attention to plaintiff. While plaintiff is stopped, allowing the pedestrian to cross, Jones runs into the back of plaintiff. Boom. Cracks some taillight, cracks some other stuff in the back. Police are called out. They do their investigation. They take their report, do all the things that the police officers are supposed to do. Once the investigation has concluded, the plaintiff fixes the damage to make sure that his car is operational in accordance with the law so that he can go on about his day. But during this time, right, he recognizes, ow, I've been injured. Exercising due diligence, the plaintiff calls his doctor. Doctor's not available. Plaintiff doesn't call off. Plaintiff goes ahead, goes to work, very responsible, does what he's supposed to do, and the day goes on. Plaintiff leaves work for lunch. He gets behind a car who in turn did the same thing that he did. The car ahead of him stops to allow pedestrians to cross the street. The plaintiff is paying attention. So when the car ahead of the plaintiff stops, the plaintiff then stops, right? Not a problem until boom, defendant number 2 rolls up behind the plaintiff, hits him again in the back. Different times, same day. Ow, I really hurt now. Plaintiff calls the doctor, doctor's not available. In fact, today's Friday, first time you're really going to be able to get in to see the doctor is going to be on Monday. Plaintiff goes to the doctor on Monday. Doctor says, yep, you should hurt. You have some injuries. Yep, these injuries are consistent with you being hit not once, but twice. With that being said, however, I cannot distinguish between which injury was the result of the first collision and which injury is the result of the second collision. What I can say is 2 collisions, accident, injuries are indivisible. 2 injuries, indivisible results. Not invisible, but indivisible. Can't figure out what injury was the result of what collision. Jacob, can you explain the holding? Would be my question if we were in class today. What is the holding? What is the holding? Was the ruling of the trial court, which was deny the motion for summary judgment that is based in joint and several liability, hold for the defendants, saying that it is the plaintiff's burden to apportion the damage, and if the plaintiff can't apportion the damage amongst the defendants, then the plaintiff takes nothing. What does the Supreme Court hold, right? Because that's where we are, Supreme Court of Arizona. They are the reviewing court. They are reviewing what the trial court did. They can't review what the appellate court did because the appellate court declined jurisdiction. So Supreme Court is reviewing what the trial court did. The Supreme Court holds, dun, da, 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 the ruling of the trial court has been vacated. Not reversed, but vacated. Is there a difference? There's a difference. What's the difference? Here's the difference. Vacated means your ruling, gone. Gone. It's gone. It's nothing there. If there's going to be another ruling, y'all are going to have to start this thing from scratch because this is wrong. Vacate it, start over, erase it. What if the Supreme Court reversed? If the Supreme Court reversed the ruling of the trial court, instead of the ruling that says the plaintiff has the burden to apportion, if I reverse it, I'm going to now say the plaintiff doesn't have the burden, the defendant have the burden. I'm not starting over. I don't have to give additional evidence. I don't have to create another record. It's just reversed. Many of you wrote reverse, and I believe that you were using that interchangeably with vacated. Those are terms of art with specific meaning. As lawyers, the only tools that we have in the fight for justice and advocacy are our words. Our words are magical. Our words are powerful. And you have to know what these words mean so that you're not using them loosey-goosey or interchangeably when they shouldn't be interchanged. The holding from the Supreme Court and Piner was to vacate. In addition, they remanded, right? Sent it back. But I'm going to send it back with you guys starting over. What is the rule of law? I would have asked B. Lewis, Asbury, and Freeman. What is the rule of law announced in this case? Well, let's go back. The issue in this case was 2. Whose responsibility is it to apportion the damage? And once that's been done, is the rule of liability to be applied to the apportionment joint and several? Or is the rule of liability to be applied several? Joint and several versus several. If those are the 2 questions that have to be answered, ergo, I should have 2 answers. Okay. Here's the prerequisite to the 2 answers. Prerequisite to the 2 answers. Plaintiff must establish prima facie case against multiple tortfeasors with injuries that are indivisible. What am I saying? Plaintiff has to establish the prima facie case of negligence. Oh yeah, I knew that. I know that you knew that, but don't forget that that's where we start. Okay, here we go. If apportionment of total damages can be sustained, if it's achievable, if it is calculatable, if it can be determined such that each defendant's liability is limited to the part of the harm that each defendant's conduct caused, then apportionment becomes the duty of the defendant. Boom. Plaintiff is probably saying, I told you guys, that's what I told you. I told you, right? But hold on, we're not done. But that's step 1. If the damages can be divided, then divide them. If they can be divided in such a way that each defendant is only liable for the part of the harm that they caused, then divide them. Who's responsible for making the apportionment? The defendants. This is where we are in Piner, right here. If, however, the judge concludes that there is no evidence that would permit apportionment, that means there's no way to divide it, there's no facts, there's no information, it cannot be obtained, it cannot be calculated because there's no evidence by which the defendants can rely on to make that apportionment, right? Then the case should be treated as one involving indivisible injuries. Remember, I said you're going to get a new rule, the indivisible injury rule. Here it is. The indivisible injury rule is used when the law says you use the indivisible injury rule, and it's used when there's an inability to apportion the damage. When is there an inability to apportion the damage? When the damages are, let's say it together, indivisible. How do you divide something that by definition can't be divided? This is what you do. If the fact finder is a jury, the jury is to be directed, guided, instructed in the jury instructions to allocate fault. Don't allocate damage, allocate fault. The jury allocates fault, and then there is a determination about the total amount of damage, right? Total amount of damage. Let's say the total amount of damage is $1,000. It's an easy number. Total amount of damage is $1,000. Jury determines fault. The judge takes the percentage of fault, multiplies that percent of fault by the total amount of damages, and the answer to that equation is what that particular defendant is responsible for. Slow down. Let's say we have a plaintiff who has total damages in the amount of $1,000. Let's say defendant one, it has been determined by the jury or the judge, whoever the fact finder is, that defendant one is 20% at fault. Got it? Multiply 20%, which is the percentage at fault for that particular defendant, time the total damages, $1,000, equals what? $200. That's how much defendant one is responsible for paying. Okay, there's only two defendants. Easy math tells us that defendant two would be responsible for $800, right? Because it's going to equal the total amount of the damage, but we're going to take the percentage of fault, multiply that by the total amount, and that's how we get how much each defendant is going to be responsible for compensating, providing recompense, paying for the injuries for the plaintiff. And I know you're probably thinking, well, you said we had two issues and we've addressed one of the issues. Took us a long time to get there, but we've come up with a new rule, the indivisible injury rule, that helps us apportion damages that are indivisible. We know how to do that, but what's the answer to the second question? Once the damages are apportioned, are those damages subject to the liability of joint and several liability, or liability as several liability? Last sentence on the screen. Each tortfeasor being held severally liable. Boom. And so now in this case, you probably got defendants saying, see, we told you we don't do that joint and several stuff anymore. So in essence, they were both right. But in the end, this is what we have. Got it? That's Piner. Why do we move from joint and several liability to several liability? Public policy reasons, right? Public policy encourages us to do what's more fair, I guess would be the way to say it. What's less unfair, right? Because in joint and several liability, if I've got a deep pocket, I understand that the deep pocket could take the hit for all of the little pockets. Now, the deep pocket does have the right for contribution. So the deep pocket can go after the little pockets if the deep pocket feels that they overpaid, but that's kind of putting it all on the deep pocket. And that kind of sucks, right? So is there a better way to do this? Well, I don't know if several liability is better, but it's different. And it prevents deep pocket shopping, right? Because every defendant is going to be responsible for the damages that are the result of their percentage of fault, right? That's a little more fair. What happens if you have a defendant who is bankrupt? What if you have a defendant who has no money? That means that the plaintiff is just going to miss out on that portion of the damages. Wow. Well, with joint and several liability, the plaintiff was made whole. With several liability, the plaintiff might not be made whole, but at least the defendants aren't paying more than their fair share of percentage of fault, 6 in one hand, half a dozen in the other. Same idea when we relying on public policy changed most jurisdictions from contributory negligence, which was really, 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 really harsh on negligent plaintiffs, no matter how little they were negligent. And we moved to comparative negligence. And then we had the pure comparative negligence. And then we had the 49% modified comparative negligence. And then we had the 50% modified comparative negligence, right? The ball's gonna move. The ball's gonna move, and the ball's gonna move based upon the collective understanding and expectation of public policy. But that's where we are. If you have any questions, please feel free to reach out, text me, call me, email me. We'll set up a Zoom meeting, whatever we need to do to make sure that you have the information that you need so that as we move forward, these doctrines are clear. Look forward to seeing you on Friday. Hopefully the temperature in the room won't be freezing, but won't be steaming, and we'll be able to focus on the task at hand, which is learning some of these doctrines. Thank you.